Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines. We have on the show Judge Tim Kelley. He's a judge on the 19th Judicial District Court. He's been there for 12 years. He's going to talk to us about a big issue that he has concern with, and that is participation in the jury system. We need folks to show up when they receive that notice because it's very important to our democratic system. So please join us on the next Legal Lines with Judge Tim Kelley. Welcome to Legal Lines. I'm Locke Meredith, and I'm very pleased to have on the show Judge Tim Kelley. He's a judge for the 19th Judicial District Court. Judge, thank you so much for coming on the show again.
Good to see you again.
Tell folks just quickly a little bit about yourself so they can understand where you're coming from.
Okay. I undergraduate school, Cornell. I went to LSU Law School, graduated in 83, went to work for the Supreme Court for Fred Blanch, who's passed away since, but we had a good time up there. Then went to work for Phelps Dunbar, stayed with them for about 12 years. Then opened my own firm with a fellow named David Gary. We had about 5 or 6 attorneys and had a good time. Then in 1996 decided to run for judge, was successful in that, and then ran again 6 years ago. And so I've been on the bench about 12 years.
12 years, a long time, isn't it?
You know, it's funny, when we first did this, we all were laughing that, can you believe that we're doing the stuff our parents were supposed to be doing, and now...
I refuse to admit I'm getting old.
You know what, last time I was here, your hair was darker.
I know. Probably have a lot more of it too, but that's the way life is. Well, let's talk a little bit about basically what you do as a judge on the trial level, because that's different than a judge on the appellate level, and particularly at the Supreme Court level. And frankly, it is the most important position as far as I'm concerned for the individual, for sure.
And in fact, that's the level that most people think of when they think of courts. It does the most hands-on work. What we do is we do the trials of the cases. If someone has a problem, they come to us if they can't resolve it, and both sides will argue to us, and we'll decide what the right resolution should be when we apply the law to it. Also, at our level are all the criminal cases. So if the state decides that someone has done something wrong, they come into court and ask us to incarcerate that person. And of course, most of the criminal cases that involve felonies, which involve hard labor penalties, they have a jury. And so the judge really is the referee for those types of things. In civil cases where we're talking about money, where people are disputing over, I got hurt, how much should you pay me for it, or you broke this contract,
right.
You know, how much do you owe me, those types of things, that's the difference between civil and criminal. The state is not involved, it's 2 private parties that are involved. And in those cases, they're also entitled to a jury, but only if the amount of dispute is over $50,000. I have done criminal for a number of years.
And the 19th JDC actually divides it up. There's certain judges that just handle criminal.
That's correct. We are all general jurisdiction judges, which means we all handle everything. However, because of the quantity of workload...
Because we are the largest population area at this point in time now.
The city and the state.
A lot of cases. How many cases did the courts handle last year?
Well, I hadn't looked at the last Supreme Court report. I know that our current dockets, each of the civil judges currently have on the docket somewhere between 11,000 and 15,000 cases, of which probably 5,000 to 7,000 are active cases.
And I want to brag on you because you're one of not a whole lot that are able to keep their docket very current, which means basically if you need a trial quick, you can get a trial quick.
Right. I think I can give pretty much anybody a 1-week jury trial or 1 or 2 week jury trial within 5 months of them being ready to go and asking you for it. That seems like a long time, but some dockets are as long as 2 and 3 years from the time.
And litigation is a long process, and something else I wanted to point out is 90% of the cases are going to be decided by a trial judge, you, or the jury that you're administering. It's only 3% or so of the cases that go up on appeal, so the folks are going to see you before, and they'll never see the appellate court.
As a matter of fact, at the appellate court level, the public doesn't come in. The litigants do not go in. There's no testimony. It's done strictly on the record and the argument of the attorneys. The attorneys go in by themselves. The parties can come watch if they want, but they cannot participate. So
there's no day in court there.
There is no day in court.
And let's explain it.
There's day in court to the extent that they're represented by someone, but they themselves don't get in to talk.
That's right. And let's talk about the difference of your role when it's a, quote, bench trial. That is, you're the one that's deciding it versus your role when it's a jury trial.
Well, on a jury trial, my role is basically to make sure all of the legal procedural things are taken care of correctly and to rule on any objections to evidence if one side thinks it's not legally admissible. I don't decide the facts.
They're the judge.
Decides the facts. They listen to the case. They decide what the facts really are. Was the light red? Was it green? They make that decision, and then I tell them at the end of the case what the law is that they have to apply to it, such as if the light was green, he had the right to go through the intersection. Then they go in, not always make it simple.
Right. Never that short.
It's very complicated cases, obviously, but that's just a quick example of what I do in that type of case. On a bench trial or a judge trial, I decide everything. And as the litigants come before me, there's no jury, and that's the kind of trial I can give you within 2 weeks of you telling me you're ready to go.
And basically, that's a very expedited process. You can submit all the information, at least deposition testimony to you in advance, pretrial briefs in advance, because you're the one that's deciding, and the trial is limited to just what specific new factual information that you would need to hear.
Absolutely. And depositions, I'm sure you've explained that to your folks before, depositions are the sworn testimony of someone who would come to court and testify to the same thing if they were available to do so or if it were convenient for them to do so. But the parties agree that they can do it by a deposition, and it's under oath, and both lawyers are there.
And in fact, we can do it by video now, too.
Absolutely. Absolutely. But you submit that ahead of time normally to the judge. The judge reads all of that or watches the video. It's easier for us to read it.
Sure.
For us to read it, quite frankly, and that's what we do. We read the trial briefs. You usually send us all the medicals, any of the contract documents ahead of time. So I know everything pretty much ahead of time. And what happens, you'll bring your clients in and they'll tell their side of the story. And then I'll apply that to what I already know about it and make a decision. And probably 99% of the time, you'll get that decision right there in court at the time, because I already have absorbed everything and been able to analyze it and to listen to your part of it and try and put that into it. Sometimes it'll be a very complicated case between companies or a tax issue or things like that, where I'll have to do additional research, because when I get into court and start listening to the arguments, I realize that I may not have fully understood the legal niceties that they're trying to argue on each side. And on those complex cases, I'll do what they say is take it under advisement.
Sometimes request the parties to submit additional briefs on the issues.
Exactly right, to help explain their position. And then I'll do my own independent research, and I have 30 days to issue a written ruling from that.
And the folks need to understand, to have a judge decide their case, either their damages have to be less than $50,000 and stipulated, in fact, to be so, or both parties agree to allow the judge to decide the case. Otherwise, it's going to be a jury trial.
And many times there'll be an amount in controversy which is in excess of $50,000, but the parties, for a number of reasons, because they both have faith in that particular judge to be fair, or because they really have a time constraint and don't want to wait until they can get a jury trial, which takes much longer.
That's right.
They'll stipulate to go ahead and have the judge decide, even though it's above $50,000.
And it's also a whole lot cheaper to try a case to a judge versus a jury, because you don't have to pay the $4,000 or $5,000 to have a doctor come testify or experts. Let's talk about the jury trial in the next segment, Judge. This is Locke Meredith of Legal Lines and Judge Tim Kelley. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith. Again, very pleased to have on the show Judge Tim Kelley. He's a judge with the 19th Judicial District Court. Again, Judge, thanks for being on the show again.
Happy to be here.
We were talking about the bench trial versus the jury trial. We talked about the bench trial as being a trial that you decide, the judge. A jury trial is where the jury decides the ultimate outcome. Let's explain to the folks, because frankly, this is where they're going to be involved in the litigation process, and it's extremely important.
It is incredibly important to our way of life. I tell every jury after we're done, when I thank them, because I talk to every jury afterwards, I tell them there's really only two things that our country asks of us, other than the payment of taxes, which is really a payment for services is what it's for. We can't go out and build our own roads or hire our own police department and things like that, so that's what the taxes are for. But the United States is a great country because every one of us, if we apply ourselves, have the opportunity to make a better life for our children than we had. And all it takes is two things that the government asks. Number one, in times of war, they ask our young women and men to fight for our cause and possibly die for our cause.
And which they always do.
And they always do. Number two, they ask us to serve jury duty.
And I just want to say, from both of us, I know, we thank our military for the service. It's unbelievable.
Absolutely. We are very, very blessed to have what we have. And thank God they're protecting us the way they are.
So bottom line is, it seems to me, and we were talking about this before the show, it seems like the democratic process is breaking down a little bit. We seem very divided.
One of the concerns that we've seen is people don't want to come serve on the jury. We understand and we appreciate it's an interruption of your life. We know that you may lose income. We know you're going to be away from your loved ones. We know it's difficult to try and adjust the care of your children and things during that period of time. We try to make it as easy as possible for you. And yet, when you get that notice and you ignore it, what happens is you help destroy a part of our country and a part of our way of life.
One of the absolute most important parts. And there are hardships. I mean, if folks come and explain to the judge why they feel like they can't be there, the judge is going to listen to that.
If you come to us and tell us there's a problem, 9 times out of 10 we'll let you out of the service and thank you for at least coming and telling us about it. To give you an example, we send out, for a capital murder trial, we'll send out 600 notices for people to come in. About 200 actually come in.
So 1/3 participation.
Exactly. And of course, on a capital murder trial,
life and death.
It's a life and death issue. We are deciding whether or not our government is going to kill somebody.
And what's so interesting, Judge, is when a juror receives that, or a potential juror receives that notice, it could be, fighting over a $10,000 case, or it could be dealing with somebody's life, and they don't know it, and it's of huge importance.
It really is. It is. I will say to the people who do show up, and you can tell that they really don't want to be there, I just say to them, listen, think about it this way. What if you were one of these people that were up here? Wouldn't you want somebody to care enough to listen to your side of it and try and decide whether or not you're right or wrong? Wouldn't you want there to be somebody there? One of the reasons we left Europe and left England was because we needed to have someone other than a jaded
dictator. That's right.
Or dictator who doesn't listen to what you say and assumes you're guilty on the front end. One of the wonderful things about our jury system is the people who serve on a jury, most all of them have never sat in that position before. When they raise their right hand and take that oath, you can see it come across their eyes. Oh my goodness, I'm deciding someone's fate now.
They're the judge.
And they are the judge. And it becomes an extremely important thing. Whether you think it's going to be to yourself or not, it does become that to you because you have the life or financial security of someone in your hands now. And you've never done it before, and so that's why it's such a great system. Because those people who have never done it before take it so seriously, and they listen to everything, and they care about what's going on. They want to get it right, as opposed to someone who may have, for 20 years, listened to these kinds of cases over and over and over again, and quite frankly, maybe grown a membrane over their ear. I don't know how.
I understand. And the bottom line is, our democratic system of government requires, for it to be effective, the participation of folks. And when they don't participate, the system starts getting skewed. And one of the reasons that you send out 600 notices, even though you're only going to pick 12 for that particular trial, is because you want a cross-section of all of the folks that are part of this country.
Absolutely.
And when they don't show up, we got a problem.
And unfortunately, the people who do show up, many of them have legitimate excuses. We have to let them go. Many of the people are prejudiced one way or another towards one party or another. And again, prejudice means nothing more than prejudging something before you know all the facts. Some people can't accept the law. Some people don't believe in the death penalty. Some people don't believe that insurance companies should be able to recover for money they put out from for an injured person. A lot of people truly have these beliefs. And if you truly have those beliefs, we don't force you to stay on the jury.
The attorneys actually have an objection for cause.
Exactly.
The judge can either say you're out of here from his questioning, or the attorney can, based on questioning of that juror, say, Judge, this guy's got to go, or this lady's got to go, and then you decide.
That's exactly right, and that's how it works. So from a great number of people, it's very difficult to get 12 people that really don't have a dog in the hunt, that really want to try and help, and I don't want to say they don't care who wins or loses, because they're very caring people, but they're
unbiased.
They're unbiased, and it's hard to find that, because we all have backgrounds that make us biased one way or another to different situations. For instance, if you have a car accident where someone's very badly hurt, and there's someone, a potential juror, the question's asked, have you ever been in a serious car accident, or has anyone, close family or friend had? Well, what if their brother has been killed in a car accident, and of course they're emotionally involved in that?
Sure.
Issue? That's not someone you want on that jury.
Certainly not someone the defense wants.
Well,
I might like them.
You might like them very much. Well, at the same time, many people really hate insurance companies.
That's right.
Hate the premiums they're paying, don't think they get anything back for it, and the question is usually asked, how do you feel about insurance companies? If someone truly just can't be fair to an insurance company because of a prejudice towards an insurance company, the plaintiff would love to have that juror, but
it's not fair to the other side.
Right, it's not fair to the other side. So that's what the process of choosing a jury comes to, is we talk to many people trying to find the few number of people that really, hopefully, truly don't have a dog in the hunt, and are willing to take it seriously and be unbiased.
And we need to point out that when the 600 notices go out, it's not just for one trial. There's a number of trials for all the various courts that are taking place that require jurors.
We have 8 criminal courts and 7 civil courts. Of those, there's civil jury trials every week. Several of those settle, so probably 2, we kind of bank on 2 civil trials a week, so we need panels for that. And you probably are looking at probably 4 to 6 criminal jury trials. So we need anywhere from 8 to 10 juries. So if you need 8 to 10 times 12 or 13,
got 100 folks. That's right.
That's a lot of people we need to bring in to help us. And the fewer, and the people that don't respond to it, that puts more pressure on the people who do.
Let's talk about this on the next segment of Legal Lines. This is Locke Meredith with Judge Tim Kelley. We'll be right back. Hello, I'm Locke Meredith, and I'd like to invite you to join me on the next Legal Lines. We have on the show Judge Tim Kelley. Welcome back to Legal Lines. I'm Locke Meredith. Again, very pleased to have on the show Judge Tim Kelley, who's a judge with the 19th JDC. Again, Judge, thanks for being on the show.
Happy to be here.
We're talking about the importance of the jury system and just how important it is that folks participate. Let's kind of take them step by step through what happens. Let's say I'm sitting on my couch and I go out to the mailbox and dadgummit, I get one of those jury summons.
Exactly.
What do I do?
It's actually pretty, we try to make it as easy as possible. You come in on a Monday morning, and that morning you and the 200 to 600 other people will be gathered in a conference room, or a large auditorium I should say, and you'll get an orientation which basically explains what your duties are. They'll go through the qualifications to make sure you meet the qualifications, and the qualifications are fairly easy to meet. You have to be a resident of East Bethpage Parish for at least a year and a citizen of Louisiana in the United States. Have to be 18 years of age. You have to be able to read, write, speak, and understand the English language. You can't be interdicted, and you can't be indicted or convicted of a felony for which you've not yet been pardoned.
And you ask them all those questions in the beginning.
I ask them to make sure. And then once that's done, you'll be broken into what are called panels of anywhere from 36 to 48 people. 48 for the criminal cases, 36 for the civil cases. And you will be assigned to a judge who has indicated ahead of time that they will need a jury that day or the next day. If the trial that you are on the panel for is not going to go forward, whether it's been continued, settled, or the defendant in a criminal case has pleaded guilty, you will be released for the week. If
your service is done?
Your service is done mid-afternoon on Monday. If you have to go to one of the courtrooms, in the afternoon you'll go to one of the courtrooms, and then you'll be questioned by the judge and by the lawyers, and if you're selected to be on the jury, then you'll serve anywhere from 2 to 5 days.
And
in that courtroom.
And in fact, there's also what's called jury interrogatories, which is just questions that the attorneys can put together to maybe expedite it, make it go really fast.
That's exactly right. You'll fill out a form ahead of time, is what it is. It'll ask you questions. You'll answer them. The attorneys and the judge will have a chance to review it ahead of time. And some of you may be released immediately.
For example, have you had a loved one who was killed in a car wreck, like you were pointing out?
Exactly.
And that helps eliminate that person quickly.
Now, if you are not selected to be on a jury the first day, there is a possibility you may be asked to come back on Tuesday or Wednesday, but you'll give them your phone number and we'll call you. You don't have to come back until we call you. And that is, some of our trials start on felony cases for criminal. They start on Mondays and Wednesdays. On civil, some civil cases start on Tuesday instead of Monday, and because we don't have enough jurors, we send our jurors to the criminal cases first, because when you're talking about somebody's liberty, that's more important than money. So we can put off someone receiving money, but it's difficult to keep someone in jail who may in fact not be guilty of the crime.
Makes sense.
That's what you're being brought in to determine. So
Sure.
Criminal comes first.
And the bottom line is the process there is pretty much the same in the civil courtroom, in the sense that the lawyers get to ask questions. If they think information has come out that renders that person incapable of being an unbiased juror, they can raise issues with the judge called peremptory challenges or challenges for cause.
Exactly right.
Explain the difference between those challenges.
A challenge for cause is one that the attorney must give an excuse for, must say this is why this person is not qualified. The law says that there are specific instances where someone cannot serve as a juror. For instance, you are a relative of one of the parties or one of the witnesses. You cannot be fair to one side or the other, those types of things. You will not follow the law, and you've established that you will not follow the law. Those are what's known as for cause. Otherwise, in a civil case, each side gets 6 peremptory challenges, and they can strike a juror for any reason they want, and they don't have to tell me the reason. The only caveat to that is they cannot systematically exclude someone because of race or gender.
Right.
So
And that's the process, basically.
that is basically the process. So you'll come in, I'll give some initial instructions, I'll call 13 people up to the jury box, I'll ask them questions, the attorneys will ask them questions, we'll tell some of them you're now on the jury, most of them will go back to jury management for instructions to give them the telephone number and things like that, and then we'll call some more people up until we get 12 folks, and then once that's done,
And have one alternate
and we'll have one alternate usually,
in
yes.
case somebody gets sick. And then the trial begins, and the lawyers present their oral arguments, basically opening arguments, tell them where they think they're going. That's right.
And most people have never seen the voir dire, is what we call it, when you select the jury, the process of selecting the jury, because to the layperson it seems long, tedious, and boring because everyone's being asked almost the same question. But it's very, very important.
Extremely important. Probably the most
So
important.
you don't see that on television or in the movies because you can't sell tickets for that or sell advertising for that, but you sure can sell advertising for the opening statements, the examination of the witnesses, the closing arguments, and then the instruction of the law you usually don't see because that's a little technical in nature. And then, of course, you see the verdict returned by the jurors.
And it's such an important role. Well, let's tell the folks about the new building. You're vice chairman of heading that up.
We are extremely blessed. We have been working on this for about 9 years now, trying to get this to be a reality. And we have a building right now that is not secure. The biggest problem we have
It's unsafe.
Yeah, the prisoners come in contact with the public and with the staff and with the judges. The prisoners' families, who sometimes are not happy with the fact that their loved ones are incarcerated, come in contact with everyone also. So we really needed a secure courthouse. This was not, the courthouse we're in now was envisioned as a municipal building, I should say, and it was retrofitted in to have the courtrooms in it, so it doesn't have the necessary security. Our new building is going to be an 11-story building. It's being under construction right now on the corner of St. Louis and North Boulevard.
$107 million.
$107 million facility.
High-tech stuff.
It's going to be high-tech. It is very, very secure. There's 3 secure areas. One is for the general public, one is for the court and its staff, and one is for the prisoners itself. And the 3 of them do not touch each other in any way. You can't walk by a prisoner anymore. In fact, the prisoners are transported up to the courtrooms on separate elevators from the court or from the public. They have their own elevators to transport them that are secure, and they go directly into a secure holding cell. So it's a much better facility. It'll be 11 stories tall, a little over 300,000 square feet. We have, because of course, with Katrina, a growth in population.
Sure.
We have accommodated a growth in the bench for more new judges to come in. So we have upwards of about 28 courtrooms where we only need 19 right now. We have 15 district court judges, and the family court will also go over there. There's 4 family court judges.
Any word on when we may have the additional judgeships?
No, we have not heard about that yet. We have to develop the statistics to show an increase in the filings and the need for it.
And the building's going to help the folks on the jury because it's tailored for them.
It is absolutely built around the public convenience. The first 2 floors, you don't have to get on the elevator. We'll have an escalator and an atrium. Jury management's going to be on the first floor. Your traffic stuff's going to be on the second floor. So all the public has a great access and a convenience.
It should be done in 2010?
Well, it's shooting for Christmas of 2009, but at the latest June of 10.
Judge, thank you so much for being on the show. It's been a pleasure. This is Locke Meredith with Legal Lines and Judge Tim Kelley. Thank you.